International humanitarian law is a law that regulates the conduct of war. It's a set of rules which seek for humanitarian reasons to limit the effects of armed conflict. It protects persons who are not or are no longer participating in the hostilities and restricts the means and methods of warfare. It's also known as the law of war or armed conflict. International humanitarian law is part of international law, which is the body of rules governing relations between states. It applies to armed conflicts. It does not regulate whether a state may actually use force. This is governed by an important but distinct part of international law set out in the United Nations Charter. Where did international humanitarian law originate? It's rooted in the rules of ancient civilizations and religions. Warfare has always been subject to certain principles and customs. Universal codification of international humanitarian law began in the 19th century. Since then, states have agreed to a series of practical rules based on the bitter experience of modern warfare. These rules strike a careful balance between humanitarian concerns and the military requirements of states. International humanitarian law forms today a universal body of law. Where is international humanitarian law to be found? A major part of international humanitarian law is contained in the four Geneva Conventions of 1949. Nearly every state in the world has agreed to be bound by them. The conventions have been developed and supplemented by two further agreements: the additional protocols of 1977 relating to the protection of victims of armed conflicts. Other agreements prohibit the use of certain weapons and military tactics and protect certain categories of people and goods. These agreements include the 1954 Convention of the Protection of Cultural Property in the Event of Armed Conflict, plus its true products, the 1972 Biological Weapons Convention, the 1980 Conventional Weapons Convention and its 5 protocols, the 1993 Chemical Weapons Convention, the 1997 Ottawa Convention on Anti-Personnel Mines, and the 2000 Optional Protocol to the Convention on the Rights of the Child on the Involvement of Children in Armed Conflict. When does international humanitarian law apply? International humanitarian law applies only to armed conflict. It does not cover internal tensions or disturbances such as isolated acts of violence. The law applies only once a conflict has begun, and then equally to all sides regardless of who started the fighting. International humanitarian law distinguishes between international and non-international armed conflict. International armed conflicts are those in which at least 2 states are involved. They are subject to a wide range of rules, including those set out in the 4 Geneva Conventions and Additional Protocol 1. Non-international armed conflicts are those restricted to the territory of a single state, involving either regular armed forces fighting groups of armed dissidents or armed groups fighting each other. A more limited range of rules apply to internal armed conflicts and are laid down in Article 3, common to the 4 Geneva Conventions, as well as in Additional Protocol 2. What does international humanitarian law cover? It covers 2 areas: the protection of those who are not or no longer taking part in fighting, and restriction on the means of warfare, in both particular weapons and the methods of warfare, such as military tactics. What is protection? International humanitarian law protects those who do not take part in the fighting, such as civilians and medical and religious military personnel. It also protects those who have ceased to take part, such as wounded, shipwrecked, and sick combatants of prisoners of war. It is forbidden to kill or wound an enemy who surrenders or is unable to fight. The sick and wounded must be collected and cared for by the party in whose power they find themselves. Medical personnel, supplies, hospitals, and ambulances must all be protected. There are also detailed rules governing the conditions of detention for prisoners of war, and the way in which civilians are to be treated when under the authority of an enemy power. This includes the provision of food, shelter, and medical care, and the right to exchange messages with their families. The law sets out a number of clearly recognizable symbols which can be used to identify protected people, places, and objects. The main emblems are the Red Cross, the Red Crescent, and the symbols identifying cultural property and civil defense facilities. What restrictions are there on weapons and tactics? International humanitarian law prohibits all means and methods of warfare, which fail to discriminate between those taking part in the fighting and those such as civilians, who are not the purpose being to protect the civilian population, individual civilians, and civilian property. Cause superfluous injury or unnecessary suffering. Cause severe or long-term damage to the environment. Humanitarian law has therefore banned the use of many weapons, including exploding bullets, chemical and biological weapons, blinding laser weapons, and anti-personnel mines. Is international humanitarian law actually complied with? Sadly, there are countries examples of violation of international humanitarian law. Increasingly, the victims of war are civilians. However, there are important cases where international humanitarian law has made a difference in protecting civilians, prisoners, sick, and the wounded, and in restricting the use of barbaric weapons. Given that this body of law applies during times of extreme violence, implementing the law will always be a matter of great difficulty. That said, striving for effective compliance remains as urgent as ever. What should be done to implement the law? Measures must be taken to ensure respect for international humanitarian law. States have an obligation to teach its rules to their armed forces and the general public. They must prevent violations or punish them if these nevertheless occur. In particular, they must enact laws to punish the most serious violations of the Geneva Conventions and additional protocols, which are regarded as war crimes. The states must also pass laws protecting the Red Cross and Red Crescent emblems. Measures have also been taken at an international level. Tribunals have been created to punish acts committed in two recent conflicts, the former Yugoslavia and Rwanda. An international criminal court with the responsibility of repressing inter alia war crimes was created by the 1998 Rome Statute. Whether as individuals or through governments and various organizations, we can all make important contributions to compliance with international humanitarian law.